My name is Roger Franklin and I'm the head of the insurance group at Edwin Co. Over the last few years, the team has been heavily involved in litigating Covid-19 business interruption claims. For most people, Covid is now, thankfully, just a horrible memory. But for the insurance lawyers, it's resulted in a slew of litigation in which policyholders try to recover some of the financial losses they have suffered as a result of the pandemic. It's a complex and developing area of law, but in broad summary, the main focus on much of the litigation now is on what are called non-damage denial of access clauses and variations thereof, and there are a number of issues still in dispute. As the name suggests, a non-damage denial of access clause, or NDDA clause as they're often called, is one that provides premises-based business interruption cover in circumstances where the cause of the loss is not actual physical damage. The cover is typically triggered by some form of authority denying access to or impeding the use of an insured building because of a danger or disturbance in the vicinity, or alternatively within a specific geographical radius, for example 1 mile. It's been said that the paradigm example of such a danger is a nearby bomb threat which leads to the neighbouring streets being closed, thereby denying access to an insured property. Partly for that reason, when these clauses first came before the Divisional Court in 2020, they were held to provide a narrow, localised form of cover in respect of a local event, and therefore did not cover a national or indeed an international pandemic. That ruling was not appealed. However, certain elements of the Divisional Court judgment were the subject of an appeal, and the view on NDDA clauses started to change when the Supreme Court handed down its judgment on the trigger for cover under notifiable disease clauses. The Supreme Court held that each case of Covid-19 was an equal and effective cause of the restrictions imposed by the government. What lawyers call the but-for test, i.e. would the loss have occurred in any event without, that is, but for the trigger for cover, that test was not determinative in ascertaining whether the test for causation had been satisfied. Instead, it was sufficient to establish a localized occurrence of the disease in combination with the wider pandemic, even if that localized occurrence would not have been sufficient on its own. What this meant, in effect, was that if you could prove an occurrence of Covid-19 within the geographical requirements of the NDDA clause, 1 mile, 1 kilometre, vicinity or whatever, then it was possible to argue that the government restrictions introduced at that time were a response to the danger, and accordingly the NDDA clause responded to the Covid-19 pandemic and provided cover under certain wordings. These principles have since been established in a number of cases in which we've been involved, notably in Corbin and King v AXA, and more recently in a case called Gatwick Investments Limited and others v Liberty Mutual. The implications of these cases are significant because they suggest that many policyholders who initially had their claims turned down may now have perfectly valid claims depending on the specific form of wording. There remain a number of issues outstanding in relation to these clauses, which are still the subject of litigation, although the position is starting to clarify. For example, one hot topic is the status of furlough payments. You may recall that during the pandemic, the government introduced a scheme to help business and the economy generally, which subsidised a percentage of people's wages in order to ensure that they were not made redundant. Insurers maintain, and the position is now supported by case law, that furlough should be treated as a saving to the insured for the purpose of calculating the business interruption claims, thereby benefiting insurers. Now, that may come as a disappointment to the taxpayers who funded the scheme thinking that they were saving small businesses, but in any event, the issue is now the subject of an appeal and is likely to be resolved sometime towards the end of this year. Perhaps of more immediate significance is the question of aggregation. An aggregate limit in an insurance policy is the maximum amount an insurer will pay to a policyholder for all covered losses during a set time period. For NDDA clauses, the inner limits of indemnity are often relatively small, at least when compared to the scale of the losses suffered, and cover a fairly short period, sometimes no more than 3 months. However, it's now reasonably clear that in certain circumstances, the limit will apply per premises and will not aggregate on a per occurrence basis, unless there is very clear wording to the contrary. This means that the limit of indemnity is potentially multiplied by the number of insured premises and by the amount of times those premises were affected by forms of government restrictions. For an organisation with a number of insured premises, all of which were closed as a result of the pandemic, that can turn a relatively small claim into a large one, and certainly one worth pursuing. For these reasons, I would advise policyholders to revisit their historic COVID claims in light of these new cases and to contact us if they need assistance in that regard. The Edwin Co Insurance practice is one of the top-rated teams in the country. We specialise in representing policyholders against insurers across all forms of corporate insurance. Our aim is to obtain the best results for our clients in the quickest time possible, and we're not afraid to back our judgment and pursue cases when it comes to arbitration or court proceedings.